for our updated or overview of Oregon Family Law Program. My name is Jenny. I'm a community librarian at Deschutes Public Library, overseeing legal services and the county law library. I'm so pleased to be able to offer legal presentations with our community partners. Tonight's presentation is hosted by Legal Aid Services of Central Oregon and is led by local legal aid lawyer, Lauren Guicheteau. Lauren, take it away.
Hi, so as Jenny said, I'm Lauren Guicheteau. I work with Legal Aid Services of Oregon at the Central Oregon Regional Office. And tonight I'm presenting on divorce and custody cases in Oregon. So first, just to give a little overview of what Legal Aid Services is, we're a statewide provider of free legal services. So we have offices all over the state. The Central Oregon Regional Office serves Deschutes, Jefferson, Crook counties, and Warm Springs. We currently have 5 full-time attorneys and 2 bilingual support staff. In order to qualify for our services, we do have some income restrictions. We can only serve pretty low-income folks, and we only take certain types of cases. So cases that involve low-income tenants, survivors of domestic violence, workers facing discrimination in employment, and public benefits issues. And just a little disclaimer at first, because we are attorneys, we love our disclaimers, but this presentation is not intended to provide specific legal advice. It's just, general legal information, and I'm not your lawyer. This is, a general presentation. If someone is interested in becoming a client of my office, then you would need to call and do an intake. The laws are constantly changing as well, so this is only relevant as of today's date, and it's important to talk to a lawyer if you're wanting to file divorce or custody at a later date, because things may have changed. So here's an outline of everything I'm going to talk about today, starting with how to find reliable legal information, all the way down to divorce custody trials themselves. So the first topic, finding reliable legal information. With the internet and everything that you can search on there, it's important to be really wary of the information that you find. If you're just Googling something, if it's not specific to Oregon, it's probably wrong. And there's also lots of stuff that's not accurate. And also be really wary of advice you get from friends, family, other people who aren't attorneys. People love to share their stories about what happened in their own divorce custody cases, but every case is different, so it's unlikely that your case will be the same. And the law is very complicated, so unless someone is actually a family law attorney, so not just any, even lots of attorneys who practice other areas of law don't know a lot about family law. So it's important to talk to a family law attorney if you want to get specific advice on your case. But I also want to highlight some, good, reliable sources of legal information online. So OregonLawHelp.org is Legal Aid's website. It provides a lot of information on family law issues. The Oregon Judicial Department is run by the state, and they provide lots of free legal information. They also provide the court forms that you need to file many things in a family law case, including parenting plans, how to, start a divorce or custody case, lots of self-help videos, things like that. And the Oregon State Bar website is also a really great source of information. There's also free legal booklets. As you can see in this picture, is the Divorce and Custody Trials in Oregon. That's a great booklet. That was created by Oregon attorneys and judges. There's also a family law handout that was created by legal aid attorneys as well. And these are also great sources of information that's going to be accurate, of course, as of the date that they're published. So I wanted to talk a little bit about the roles of lawyers. So there's multiple options for hiring a lawyer if you want to in your custody and divorce case. We, of course, always recommend that people hire a lawyer, but that's not always an option for someone. So there's various ways that you can do it. Sometimes you can just pay for a case consultation to talk about your case and get more information from a lawyer. There's also such things as what's called limited scope services. So you're not necessarily hiring a lawyer for your full case, but hiring them to do pieces of your case or to review certain forms as you go through or give you advice as you go through your case. And then there's full representation, which is traditionally what people think about when getting an attorney for your case. They go to court for you, they, write and file all the documents for you. And finding a lawyer, especially in this area, can be difficult. One good strategy is to ask friends or family members, people you know, about attorneys that they had a good experience with, that they worked well with. There's also the Oregon State Bar Lawyer Referral Service. And this is, through the Oregon State Bar, and they can help connect you to an attorney in your area. There's like a $35 fee. And we always recommend that you talk to more than one attorney if you can. So you make sure you get a good fit and that it's someone that you want to work with through a somewhat long process. Also, it's important to always look up a potential lawyer to see if they have, they've been suspended or they've been disbarred or they've had other disciplinary records. And you can do this if you go to the Oregon State Bar website. So this shows you what it looks like. You can search them in the little box. And at the bottom, it has some of the information from one of my previous coworkers. But then it has the show disciplinary history. And if you click on that, it'll show you if there has been any disciplinary history for that attorney. And it's important when you're working with a lawyer that you know what you're getting in with and that they know what you expect of them. So when you sign any contracts with the attorney, often called a retainer agreement, it's important that you review it, you ask questions, and have a really frank conversation about money. Let the attorney know how much money you can budget for a divorce or custody case and what they can do with that budget to really maximize the services you can get for the amount of money. Also talk to them about what you're expecting, and what's realistic for your case, given, their schedule, their expertise, the way they practice. And I think one of the things people really struggle with is communication with attorneys, making sure that you know how fast they're going to respond to things and how fast attorneys expect you to respond, right? So having that foundation where you understand each other's expectations is really important. And I also want to flag, this frank conversations about money is important because often people they'll hire an attorney who has say a retainer. You have to pay $5,000 up front to get this attorney to take your case. And if you only have $5,000, you give that to the attorney, they start working on your case. Halfway through, after they've done some things, they've used that full amount. And then they'll say, okay, I've used that. I need another $5,000. And if you don't have that, then they'll terminate services and you have to do the rest of the divorce case on your own. So it's really important to know that upfront amount may not be for the full case. So talk to the attorney, let them know how much money you can budget and strategize around what that budget is. Now, just sort of a big overview of the divorce case process. So for an uncontested divorce or custody case, there's, two parties. So you have the petitioner who files the first paperwork called the petition. And then you have the respondent, who's just the other party in the divorce or custody case, who's going to respond or not. So the petitioner, that first person starting out, files the paperwork with the court. Then they have to serve the other party. And I'll talk a little bit more about what service means. Usually you have to complete a mandatory parenting class. And then if no response is filed, if the other party doesn't actually file anything with the court, doesn't give you any information, then the petitioner can actually ask the court for a default judgment. They can say, hey, court, I did all this stuff. No response has been filed. Give me what I asked for. And once they file that paperwork, the court will sign that default judgment and the case will be final. The divorce or the custody case will be done at that point. However, if it's contested, it's a longer process. So again, similarly, the petitioner files the paperwork as the other party served. Then the other party files a response, making it a contested case. Both parties then have to complete the mandatory parenting classes if children are involved. And there's sort of a process where the parties can attempt to resolve any issues through mediation or negotiation. If the parties can't come to an agreement, then it goes to trial and the court will make a final judgment. And we'll talk a little bit more about these pieces as I go through. So the first step, starting the divorce or custody case. This is a petition. On the left side of this slide, you can see this is kind of what a petition looks like in Oregon. And this document is where you put, the petitioner puts everything that they want to get out of the case. If you have an attorney, then the attorney will usually draft this themselves. But if you don't have an attorney, these court forms are available at the Oregon Judicial Department. There's also usually a fee to start a court case. If you're low income, you can request a fee waiver for the $300 filing fee. And it generally doesn't matter who files first. Some people think that they need to file first before the other side. It doesn't matter that much for the outcome of the case. And if you're doing this yourself using, the court forms, there's also ways to get help completing your paperwork. So you can always hire an attorney for a consultation to review it. If you have an attorney for that case, they'll draft it themselves. And there's also court facilitators. So most county courts in Oregon have family law facilitators who will review your paperwork. They cannot give you legal advice, but they can tell you if you've left anything out or you've, left blank somewhere or if you've done something a little bit wrong. And that can really help getting everything filled out and filed correctly the first time. And then service. So serving is just giving the other party the paperwork to make sure they have proper notice. But there's special formal processes that are required at the very beginning of a case. So there's 4 types of service. So there's personal service, where you have someone who's not a party to the case. So, friend, family member, or a private process server that's hired, that's their job, will go and give the papers to the other side in person. Substitute service is also a formal process where you give it to somebody else who lives at that house, who's over the age of 14 as the other party. Sometimes you can serve them at work, things like that. But there's very specific rules about that. There's also the acceptance of service. And if you look on the left-hand side of this slide, it has an acceptance of service form where the other side, the other party, says, yeah, I'll accept documents. You've emailed them to me. I'm happy to accept them. But they have to fill it out and file it with the court before it's formal. If for some reason you're not able to serve the other party, you try to serve them formally, you don't know where they are, they're avoiding service, something like that, you can also go to the court and request alternative forms of service. But it's really important that you show the court that you've tried to serve them every way you can and hasn't worked. And then you can ask the court for things like service by mail, service by email, and Facebook message and text message, things like that. But you have to show that that's really necessary. But it's also important to know that once, that formal service at the beginning of the case is done, you still have to serve the other party with paperwork, but regular mail is sufficient. Every time you file anything with the court, you have to give it to the other party, and you have to let the court know that you've given it to the other party. There's also an automatic statutory restraining order. And what this means in the divorce context or the custody context, it's not like a restraining order as we usually think of them, saying you can't contact the other party. It's a specific thing that just means you can't change insurance. So you can't go and cancel your health insurance or your car insurance or anything that covers either party or any children involved in a case. And you also can't go and sell things. So if it's a divorce case, you can't sell your house or sell your cars or hide assets or take out big loans. And if one party needs to modify this automatic order or one of the parties is violating, you can request a hearing on that. And then there's the response. So one party goes, files the petition, serves it on the other side, then that party files the response. They have 30 days to do it from service. And in the response, you essentially tell the court what you disagree with that was in the petition. You say, other side's asking for this. I disagree with that. You can also do counterclaims. So saying, and in addition to disagreeing with them, I want something else, X, Y, or Z. There's also a filing fee for filing a response, and this can also be waived if you're low income. So, as I mentioned briefly before, if no response is filed, then the petitioner can ask for a default. And so you wait the 30 days, they haven't filed anything, then you file paperwork with the court asking for default order and a default judgment. The court will review this paperwork. It has to be filled out properly. And you also have to have proof that the respondent was properly served. And if there's no issues, then the court first enters a default order and then a default judgment. So you get those two things, which is a little confusing. And the default judgment also has to match the petition. So you can't add in anything new or, change terms to make them more specific. So what you ask for the petition is kind of what you're stuck with in the default. But it does finalize the case pretty quickly. And if a response is filed, then it becomes contested. And it's important, as if you're the petitioner, to review the response to see what the disagreements are and to see if you can try to resolve those before, so you don't have to go to trial. So there's a few mandatory items that you have to complete before going to trial. If children are involved, the two things are parenting classes and mediation. So for parenting classes, these are intended, the court wants people to take these classes so that they learn about, co-parenting, and they also learn about how the court process and separation affects the children. In Crook and Jefferson counties, the class is offered through Best Care Treatment Services, and in Deschutes, it's offered through the Family Resource Center. So you want to contact those directly to sign up for the classes. Sometimes there are fees, and often you can get those waived as well. Once you've taken the class, completed it, then you have to file a certificate of completion with the court so the judge knows that you've completed it. Some counties also have mandatory mediation just for custody and parenting time piece. So Deschutes currently does not have this, but they probably will in the future. They're just in transition right now. I do believe that Crook County and Jefferson County has this. So a mediation is essentially where both parties meet with a third neutral person who tries to help them come to an agreement, figure out what they want their parenting plan to be. And a parenting plan is a specific form that you fill out that says, where the kids are going to stay and when. And it's really important to know that you're not required to come to an agreement in mediation. So if you go to mediation and the other parent isn't being reasonable or you're not able to come up with something you agree on, you don't have to agree on anything. It just goes to trial. And then there's lots of optional items to complete before trial that are often, important and that you should do, but not necessary. And so mediation of everything else. So the mandatory mediation is usually just for parenting time and custody. But if it's a divorce case and there's property or other things in dispute, sometimes doing mediation can be really helpful to sort of narrow what issues are going to go to trial or resolve the case completely. But we also really flag that it's important to be wary of mediators who aren't attorneys or, former judges, because sometimes they don't really know the specifics of the law and they'll help you come to an agreement that's not actually enforceable in court or that isn't drafted properly. There's also just settlement communication. So you don't necessarily need to have a formal mediation. You can just talk to the other side or their attorney about what you want, what they want, and come to an agreement and have that entered into the court as a judgment that you both agree upon. It's also important to know that statements made during settlement communications are not supposed to be used in court. There's special rules that keep that out. And then there's discovery, which is the name of sort of the big process for requesting documents from the other side and giving the other side documents that they request. So if you don't have access to the other parties, bank accounts, their property, their debts, other financial documents, it's important to request those during the court process so you know what needs to be divided up. Usually, if you request them or the other side requests them from you, the party has 30 days to respond. Sometimes one party will request things that are sort of inappropriate or just too burdensome to do. And there are objections that you can make to discovery requests. And so if you have, questions about something that you've been asked to produce that you don't think is appropriate, or if the other side isn't producing documents they're supposed to be producing, then that might be a good time to consult with an attorney on that piece. There's also temporary court orders. So you can get temporary custody and parenting time while the divorce or custody case is pending. That sort of goes in place until the final judgment is entered. You can get temporary spousal support or temporary child support or other temporary orders regarding real property, personal property. So something that says one person gets temporary use of the family home, or the parties get temporary use of various cars while the case is pending. And now I'm going to talk about other court hearings that kind of get set. So once you get to the contested stage, the court's going to set a pretrial conference and a trial readiness hearing. And those are usually somewhat informal. They're just for the court to figure out where the parties are. Are they ready for trial? Does anyone need a continuance? How long is the trial going to be? Things like that. Then there's the other hearings. So those temporary orders I discussed. If somebody files a motion because there's discovery issues or other types of motions, those hearings get set by the court. And then at the end, there's the actual divorce or custody trial. It's important to know that some hearings are actually physically in the courthouse and other hearings are over the phone or like a WebEx, which is like the video app that the court uses. And when the court sends out notices, it'll indicate whether the hearing is in person or not. But it's important to know if you need to be at the courthouse or if there's another way that you need to, connect to the hearing. And there's also rules about evidence needing to be submitted several days in advance of a hearing. So if you need to reschedule a court hearing, then it's important that you submit a motion to continue, or if you don't have an attorney, you can write a letter to the court saying why you can't and requesting that it be rescheduled. It's important you do this as soon as possible, though. If you wait till, a couple of days before a trial, the judge is likely to deny it. So for divorce and custody trials, there is two types of trials you can get, one or the other. So specifically for these cases, there's an informal domestic relations trials that have been created, and there are then alternatively a formal trial. So the formal trial is sort of the traditional trial, like you see on TV. Parties have to follow the rules of evidence. And so these can be pretty tricky for people who aren't attorneys. For example, anything that someone else writes other than you or the other party is usually hearsay. So if you bring in a letter from a family or friends, or you bring in medical records, but you don't have the doctor there to testify, court's not going to look at those because those are hearsay and they get excluded. You are allowed to have witnesses, though, who can testify and talk to the court. And we find that people who have attorneys often have advantages in a more formal trial setting. The informal domestic relation trial is intended for people without attorneys. Both parties have to agree and actually opt in affirmatively and file with the court that they opt in. But what's nice about these is that there are no rules. The rules of evidence don't apply. So you can bring in letters, you can bring in school records, medical records, sort of any sort of things that people tend to generally rely on can be brought in and presented to the judge. However, you're usually not allowed to have witnesses. And if attorneys are involved, it's usually in a much more limited role. So now I'm going to give you sort of the broad overview of what a traditional trial looks like. So you have opening arguments, which are really just where each party presents a summary to the court. If neither party is represented, often the court will skip the opening argument. And you have the evidentiary portion, which I will get into a little bit more later. And then you have, but this is essentially where you present your testimony and exhibits, things like that. And then you have closing arguments, where each party makes the legal argument why the judge should rule in their favor based on the law and the evidence that was presented. And then the judge will make their ruling. And so now talking about that, just that evidentiary portion of the trial. First, the petitioner gets to go on first and present their case. They can testify themselves, they can call witnesses and present any other evidence that they have. And then the respondent has the opportunity to cross-examine the petitioner or any witnesses that they call. Next, it goes to the respondent's case. Respondent gets to testify, call witnesses, present evidence, and then the petitioner gets to cross-examine them and ask questions of the respondent or any witnesses. And then there's the rebuttal case at the end. So the petitioner gets to go one more time to address any evidence that the respondent brought up that was new in the respondent's case, or maybe to recall a witness if they need to. And then the respondent can cross-examine any of those witnesses. However, the respondent doesn't get an extra turn to go. So usually it's petitioner, respondent, and then a rebuttal. And so these next sections, I'm going to talk about like sort of the different types of issues that can come up in the case and what evidence the court's looking for. So custody is involved in the case. What that means is, so there's custody and parenting time in a lot of these cases, and custody determines who will have the authority to make major decisions for the child. So, who gets to make those choices? And these choices include, the child's religion, where the child goes to school, what healthcare a child will receive, or where the child's going to live. Parents can have joint custody or sole custody. So if there's joint custody, both parents get that decision-making power. And if it's sole custody, then it's one parent or the other. And the court will only award joint custody if both parents agree to it. So if you don't want to agree to joint custody, the court's not going to award that. The court considers the best interest of the child when deciding custody and looks at factors that are laid out in the statute. So if custody is at issue, you should present evidence that shows, who is the primary parent. And when I say primary parent, I mean, who did most of the caretaking responsibilities? You can go through a daily, an average day with the child, who wakes up the child, gives them a bath, gets them dressed, feeds them breakfast, takes them to school, does homework, goes to the doctor's appointments, puts them to bed, all of that. What's the child's relationship with each parent? Was there domestic violence? And if so, explaining what occurred and providing evidence of that to the court. Was there any child abuse or other safety concerns? Does the other parent have drug or alcohol issues? And another thing the court really cares about is if you encourage a positive relationship with the other parent for the child. They really do care about whether parents are being appropriate when they're talking about the other parent with their kid. And they also look at relationships with family members, either, is there extended family in the area? What are those relationships when deciding custody? Parenting time, on the other hand, is where the child will be, right? So which parent will have care of the child and how often? So often people say, I want 50-50 custody. And what they really mean is they want 50-50 parenting time. And you have to present a parenting plan to the court, which spells out at a minimum the amount of time each parent will have with the child. It can also include things like rules when you have parenting time, no drinking, no, physical punishment, the types of things you can say to a child. You can have rules around exchanges, where those will occur, who will do them, things like that. And the Oregon Judicial Department has some great sample parenting plans that parents can use and submit to the court. And parenting time is also decided on the best interests of the children. So when parenting time's at issue, you want to present evidence and testimony that address how old the children are. If they're really young, a different type of parenting plan will be more appropriate than if, they're in their teens. What are the parents' schedules? What are the children's schedules? Do they have, when do they go to school? What are their extracurricular activities? How close do parents live to each other? How long will it take to transport kids back and forth? Are there any safety concerns? And, do the children have any special health concerns or other issues that the court needs to take into account when deciding what parenting time will be? Another issue in these cases is child support. So child support is the money that one parent pays to the other parent to meet the needs of a child. And it's calculated using a formula that's created by the state, the child support guidelines. And you usually use an online child support calculator that you fill out with your court paperwork. That kind of you put in like income information, and it spits out what the child support should be. It's also based on how many overnights each parent has with the child. And so if child support's an issue, things you should present to the judge are how much money does each parent earn, from employment or from other sources of income? Do you have does one parent, have investments or money from family? Does somebody receive spousal support from a previous marriage? Do they get public benefits or social security benefits? Does either parent have something that creates a barrier to them working? Do they have a disability, or are you too busy with childcare that you're not able to get a job? What are the health insurance costs or other costs around, taking care of the child, such as, childcare costs like paying for daycare, things like that. And then in divorce cases, but not custody cases, there'll be the division of property. So property includes real estate, it includes financial accounts. It also includes personal property, like your clothing, your furniture, vehicles, sort of all of the things that you've accumulated. And in a divorce case, a judge should divide property that was obtained during the marriage, mostly 50-50, unless they make a determination that something else is just and proper. And even property that was obtained before a marriage can be divided in the divorce if the judge finds it just and proper. So it's important to remember this is really about what is equitable, what is fair. The judge will look at both parties and how long a marriage has been when they divide up the property. So you want to make arguments to the judge about what you think is fair and why. So some evidence and testimony that's important in property division is, what property is there? The judge isn't going to know. So it's really important that you create, lists of all the property that's relevant, that both parties own. When was it acquired? Before the marriage, during the marriage, after separation? How much is it worth? Are there any loans or mortgages on the property? Who do you think should be awarded the property and why? Why is that division fair? And if one person should be awarded more property, should the other person be awarded what we call an equalizing judgment, which is sort of like a lump sum of money to compensate for that unequal division? Debts are also important to make sure you include in a divorce case. Credit card debt, loans, mortgages, student loans, all those things come into the case. Usually they're divided 50-50 if they're acquired during the marriage, but the judge can decide if it's fair or equitable to do something a little different. So things to talk about to a judge are, making sure you include all the debts that both parties have, how much the debts are worth, whose name is on the debt. So even if it's just in the other person's name or just in your name, if you're married, you're still liable for those debts unless they get divided in the divorce. So making sure those are all included and letting the court know, whose name it's in, is it a joint debt? And then how those should be divided and why that division is fair. The next issue that comes up in divorce cases is spousal support. So spousal support is when a judge orders one parent or one party to pay the other party a specific amount of support money each month. There really are no hardline rules for this, unlike the child support calculator, which you put the information and it spits out child support amount. There's nothing like that for spousal support. It's very discretionary based on some statutory factors. And there are 3 types of spousal support that the court looks at. So there's maintenance spousal support, which is essentially to keep someone in the lifestyle that they're currently used to with a marriage. And usually this is only granted when there's a long-term marriage. So it kind of keeps the parties at their current situation going forward, essentially until they die or there's, a huge change in income on one side or the other. Then there's transitional spousal support, which is saying you're going to have spousal support, but for a limited period of time to sort of transition you from this marriage onwards. If you need to go back to school and get a little more education to get back into the workforce, we'll give you this transitional support during that time. And then there's compensatory spousal support. So if one spouse, is working and paying for the other spouse to go to school, and then that spouse graduates and they get divorced, you can say, hey, I put all this money into their education, which they are now going to benefit from. I should be compensated for that. And so the things to talk about with a judge or present evidence or testimony around when dealing with spousal support are each party's income, any, sources of money they have, the ages of the party. If both parties are older, and that's, important. If parties have disabilities, that's important. If there's any other barriers to working, that also comes into play. The educational backgrounds of each party, work experience. If you think the other party could be earning more than they are, then you would present, evidence on what income they could be making. And also whether one party supported the other party financially during the marriage. If one party stayed home and took care of the house and took care of the children, that's also relevant. And all of that can come in to the spousal support determination. So what a judge does not want to hear about in a divorce case when there aren't children is really anything that's not related to the division of debts or property. So Oregon is a no-fault divorce state. So the court's not going to consider, cheating or unfaithfulness of any time. They don't want to hear about it. Mental health issues, drug, alcohol issues, criminal history, bad acts by the other party, unless it's directly related to like debt or property division, they don't want to hear about it. So now we've gotten to the point where the judge is going to make the ruling. So what does that look like? The judge will first, hear everything, go through all of those steps, closing arguments. Then they will decide findings of fact, which mean if there's if you say one thing, the other party says another thing, they will decide what they believe is true and what the facts are for the case. And then the judge will then decide how the law will apply to those facts that they've decided are the truth. Sometimes judges will tell you their decision at the end of the hearing. So you're at trial, everybody's gone. The judge will, tell you, in person or over the video or phone, this is what I'm deciding. This is my ruling. Sometimes the judges will say, I'm going to take this under advisement, and then they'll issue a written opinion, which will usually be mailed to the parties. So the case isn't necessarily over, though. So it's not final until the judge signs the judgment and the judgment is entered into the court case. So if either party has an attorney, the attorney usually drafts that judgment, might go back and forth a little bit between the parties to get the wording, perfect. But if attorneys are not involved, sometimes the parties have to do it themselves or the court will prepare it. And so just sort of going back to that slide, just because you've gone to trial doesn't mean your divorce is final. It's not until it actually gets signed by the judge and entered by the court. So it's important to remember that. And even if something is final, sometimes you can get modifications. So the last thing I'm going to talk about is when a modification is appropriate. So custody can be modified if there's been a substantial change of circumstances, but you have to show things have really changed. Parenting time can be modified if the change is in the children's best interest. Child support and spousal support can be changed if there's been another substantial change in circumstances. One thing that's a little trickier is the division of property and debts cannot be modified unless one party discovers that assets have been hidden or, new evidence that was previously unknown or couldn't be known by then. So it's important to remember that if you've just gone to court, you got a judgment you don't like, it's unlikely you're going to be able to modify it right away. There has to be usually a large change for the court to be willing to modify what that judgment is going to be. And so that's the broad general overview of divorce and custody cases in, Deschutes, Crook, and Jefferson County. This last slide has my office information to call if you are interested in becoming a client. And it's, I always recommend go look at those legal resources that are earlier in the slideshow. that have great information online. There's great forms that people can use on their own. And of course, make sure if you're going to get an attorney that there's someone that really works with you and that is able to fit your budget so that you can get assistance through the entire custody or divorce case.
Fabulous. Thank you so much, Lauren. That was
You're welcome.
information. And I really like that section at the beginning about finding a lawyer. I think that was really
Great.
That was new, and that was really helpful too, I think. So thank you for being here.
No worries.
Yeah, and if anybody has any further questions, feel free to reach out to Lauren, Legal Aid, or to us at the Law Library. We can help direct you to these resources as well.